A question that I've been getting a lot lately is if I don't have a production company for my indie film yet, but I'm collaborating with a group of other people on the film, whether it's on the script or fundraising or something else, what kind of agreement should I sign with the people who I'm working with? The first thing that I'll say is that, in my opinion, you should form a production company, which is usually a limited liability company or an LLC, as soon as possible. The first and foremost reason that I'm always harping on is to protect yourself and the other producers from personal liability. If someone sues you for reasons that have to do with your film, and you have a company that owns the film rights and is writing the checks and so forth, rather than you doing those things, often the law is going to require that person to sue the LLC rather than you individually. That means they're only going to be able to go after the assets of the LLC rather than your bank account, and that's a good thing. Also, people tend to prefer to deal with a business entity like an LLC rather than an individual. If someone's considering investing in your project, they're probably going to feel more comfortable writing a check to a limited liability company rather than to you, Joe Producer. And the fact that you've actually gone to the trouble of taking the legal steps that are necessary to form an LLC shows that you have some idea of what you're doing. But it's true that forming an LLC is going to take some work. The biggest chunk of work you're going to need to do to form an LLC is to draft an operating agreement, which, among other things, will show what percentage of the LLC each owner owns. It's going to talk about who's going to manage the LLC. It'll talk about how many owners need to vote for the LLC to take specific types of actions, like dissolving itself or taking on a loan or something of that nature. And of course, you're going to need to work out what the terms of that agreement are going to be between you and your partners. And depending on how difficult your relationship with your partners is, or how much haggling they're going to require, that may be a big task in itself. Anyway, if you feel like the phase of the project that you're in is just too early right now, and you don't want to commit to forming a production company yet, let's talk about what you can do from a legal perspective to protect your interests. But first, a couple of obligatory disclaimers. First, this is not legal advice, because if I were going to be giving you legal advice, of course, I would need to understand your personal situation and your specific needs. And right now, I'm just a random lawyer talking to you on the internet. And second, this video is going to deal with matters of U.S. law. So if you are based outside the United States or you're making your movie outside the United States, then the legal concepts that I talk about in this video might not apply to you. And of course, if you find the content of this video helpful, please like this video and subscribe to this channel so I can keep providing this kind of educational content to enterprising, hungry young filmmakers such as yourself. So hopefully I haven't been keeping you in too much suspense about what I think you can do contract-wise before you form a production company. One thing you and your co-producers can do is sign what's called a collaboration agreement. What is that? Well, a collaboration agreement is an agreement made early in the process between the producers of a film that usually has the following features. It describes the roles that the producers are going to play in the production, like producer or writer-director or something like that. It makes clear what intellectual property rights each of them holds, and it also makes clear that you and your co-producers have no intention to form a partnership or a joint venture or any other kind of business entity before you form your LLC. Of course, if you do already have a production company for your film project, there probably isn't any need for you to form a collaboration agreement. The producer's responsibilities and the terms of their compensation are going to be spelled out in their individual agreements with the production company if you have one, and there's no need to put them in this separate contract. But anyway, let's get more in depth into each of the delicious ingredients of a collaboration agreement that I just talked about. Let's first talk about why and how the collaboration agreement is going to define the producer's roles. The agreement is probably going to define both the activities the producer is going to do right now in the development phase and those that the producer is going to do later when the parties more formally get into pre-production and production on the movie. The agreement is going to talk about what everyone's going to do during the development phase to make sure that everyone feels like they're making a fair contribution and none of the producers feels like they're doing all the work and getting taken advantage of. So the agreement might say, for instance, that each producer is going to make their reasonable best efforts to raise funds for the film. One reason the agreement's going to describe the role that each producer is going to play in development, pre-production, and production is to make sure that it's understood among the producers that none of them is going to get cut out of the project when it comes time to make the movie. The thinking is that if you assure everyone in writing that they'll get to be involved in making the film, they're going to be more motivated to take steps to develop the film, whether we're talking about fundraising or attaching talent or writing the script or what have you. What kind of language is the agreement going to use to describe the role each producer is going to play in pre-production or production? Usually it's pretty general and it's going to mirror the kind of language you'll see in agreements to retain people to do various tasks in the production of a film. Like if someone's going to be a producer, it'll probably say they'll do the activities traditionally associated with the producer on a feature film. If someone's going to direct, they'll do the traditional director duties, and so on and on. Any further details can be worked out when the producers actually form a production company and the company enters into contracts with each of the producers that go into more depth about what they're going to do and how much they're going to get paid and so on. Another thing collaboration agreements usually do is specify who holds the intellectual property rights associated with the screenplay for the film. If one of the producers signing the collaboration agreement is the screenwriter, for instance, the agreement will say that they hold the copyright rights. Or if the writer is someone outside of the group, the agreement is going to recite their name and say that the parties contemplate having the production company acquire the right to make a film based on the script from that person later on. The purpose of this is to make sure that there are no disputes down the road regarding who the author or authors of the script are and who owns the copyright rights associated with the film. This is important because if someone is considered a so-called joint author of a copyrighted work under U.S. copyright law, they are going to be considered to be entitled to an equal share of the profits from the film. That is, an equal share to every other author. So if we have language making clear who holds the IP, we help make sure that no one else can unexpectedly come along later on, once the movie started making money, and say, hey, I'm a joint author of the script or something like that, and claim to be entitled to a greater share of the profits than what everybody thought they were going to get. The next thing that's important to do in one of these agreements is to make clear that there's no partnership, joint venture, or employment relationship among the parties. Under U.S. law, if two or more people work together on a commercial project, that is some kind of business project for profit, even if they don't talk about forming any particular kind of legal entity, they may still be considered to have formed a partnership or a joint venture under the law. If that happens, and the parties don't agree in writing how the profits are going to be divided up, the law is going to view each party as, again, entitled to an equal share of the profits. That may not be how you want to divide up the film's profits at all, and making any kind of attempt to divide up the film's profits at this stage may be risky. After all, if people invest in your film, you're going to be giving them a share of the film's profits in exchange for their investment. You may also want to attract key cast or crew members by offering them shares of the profits, so-called back-end points. If you start dividing up the profits from your film between the producers at this early stage, you limit your ability to promise shares of profits to investors and talent and crew, and that may hamper your ability to raise funds or get the best people involved in your project down the line. So you want to make clear that there's no partnership or joint venture to ensure that no one can come back and claim that because they were part of the producer group and the producer group were partners under the law, that means that that producer should get a bigger share of the profits than what everybody thought they were going to be entitled to. Another point to make about these collaboration agreements is that they usually stay in effect only until the parties form a production company. That is, they'll contain language saying that they'll terminate once the parties form a production company, when the company has signed contracts with each of the producers or something along those lines. This is because the company is ultimately going to enter into a long-form agreement with each of the producers, which will hire them to produce the film. It'll detail their responsibilities. It will say how they'll be paid and give the period of time for which they're going to work, and so on and on. Also, the company's operating agreement is going to show what share of the company each producer or investor owns, and thus how any portion of the movie's profits that go to the production company are going to be divided up. You want to make sure that the collaboration agreement doesn't limit or hamper the production company's ability to enter into contracts with the producers on terms that are going to allow the movie to get made. Also, ultimately, the writer is going to enter into a contract with the production company, assigning the company the right to make a film based on the script. If the writer is a party to the collaboration agreement, and that agreement says the writer owns all the IP associated with the script, you want to make sure that doesn't interfere with the writer's ability to license the film rights to the production company later on, or create any kind of ambiguity that would allow the writer, if the movie does start making a bunch of money and they get greedy, to demand more from the production company. Finally, as I say maybe too often in these videos, it's important to have a clause in the agreement saying that if one of the producers sues the others and accuses them of breaching the agreement, the producer who's suing cannot get what's called injunctive relief, which means, in this context, an order from a court that prevents the film from being effectively shown to the public. Instead, the best they can do is get what's called damages, which means an award of money that compensates them for their loss. Your distributor will ask you to have this kind of provision in every contract that you sign with people involved in your film. The reason is that if someone involved in the film were able to get a judge to order the distributor not to distribute the film, the distributor would then lose all of the value of the time and money that they put into this, so that their entire investment. Or the person suing could at the very least use the threat of an injunction to extract more money from the distributor or the production company, and you want to make sure they can't do that. So I hope this has been helpful to you in understanding why and how to form a collaboration agreement early on between indie film producers. And thanks so much for watching.